All right, welcome everybody. We'll give it 1 second for people to roll in here. There we go. Thank you so much for joining us today. I'm really excited to welcome Fourscore Law, one of our legal partners, into our first event together, and it's going to be pretty cool. I hope it's going to be a little interactive. We got some polls prepped. If you checked your email, we sent out what we call pre-work, but basically just a contract that we're going to use as an example today to walk through legal agreements. So before I even get to the contract, let's talk about legal agreements in general. So our audience today is a mix of people from across the Gus ecosystem. Some of them might be Gus Launch founders who have like a repository of legal templates that has been, blessed and created in, collaboration with lawyers to help streamline, your company's back office and operations. Other people are coming from the larger Gus ecosystem who, might have an entity, might not, might have their own contracts, might not have a lawyer, have an uncle who's a lawyer who told them to get an LLC, who knows? But at some point, being a startup founder, you're going to encounter legal contracts. And all founders that I've known, especially the CEO and the C-level, end up getting a grasp of legal language as they navigate building a company. They're not going to be lawyers themselves. They'll usually work with trusted counsel, but being able to digest legal terms, NDAs, contractor agreements, terms of service, and being able to collaborate not only with your counsel, but with your team and your vendors and your partners, and even eventually your customers, is essential to really running a company successfully. You want to understand kind of what you're signing when you're signing things. So this is the first of a kind session that we're going to do, which really is like going through an actual legal document and highlighting, what some of these phrases and clauses mean, so that you're not just blindly signing on the line or scrolling down to page 20 and just docu-signing it or whatever you're using, or you're using Gus Launch. And that's exciting. So for everybody else, yes, we're going to record this. We'll send a recording out after we wrap, probably a day or two. Throughout, we welcome questions, so please use the Q&A functionality to answer any questions. We'll pull up some if they're contextually relevant to the topic at hand. And that's it. I'm happy to introduce Max and Jesse. If you guys want to give yourselves a quick little background about both the firm and yourselves, and then we'll dive in.
Sure. Hopefully everybody can hear me after our technical difficulties before we started. My name is Jesse Jones. I'm the founding lawyer at Fourscore Business Law. Fourscore and Gus have had a partnership for probably 5 years, maybe a little bit more than that.
I think you guys were in our original batch of legal
partners. Yeah, I think it's been almost since day one of Fourscore. So our firm Fourscore is about 5.5 years old now. And we like to work with entrepreneurs and founders and businesses that are innovative. Is kind of how we look at it. We say that ideas deserve opportunity, and that really kind of lends itself to what we're looking for when we work with companies. Our work basically lands in 3 buckets. We do a lot of venture financing work. We do a lot of mergers and acquisitions transactions, and then we serve as outside general counsel for most of the companies that we represent. We probably have, a couple dozen clients that started out at Gus and then, eventually get to the point where they need to talk to an attorney. And it's been a good partnership, but I think it's the first time we've done any type of learning event. So this should be fun. I'm looking forward to it, and I'll let Max take it away from there.
Thanks, Jesse. Yeah, I'm Max. This is actually my law is a second career for me. Before I was actually working with sales and software technology, from client server solutions to SaaS. Actually saw the cloud being formed. So while I enjoyed it, I wanted to have more conversations around the legal aspects of the business, which is what I was enjoying originally. So I figured I should do that. And so now, successfully, I've actually been able to give legal advice to clients, startups, small companies, high growth, with the context of business applications of legal agreements throughout. So that's my primary role. Usually I'm in the weeds with the documents and agreements and legalese that admittedly, probably nods off a whole lot of people of the day, but I enjoy all of it. And I think hopefully the quick session today will be able to kind of show you how those agreements will impact your business, why they can be exciting or at least important if nothing else, and gain some knowledge about what those interactions are between the law and the business.
Yeah, and they can be exciting. I'm a technologist as a background, and moving into more of an operations role and a leadership role in Gus, I have found, and building software to, structure legal documents and the relationships between them and working with lawyers, eventually, like, what I like to tell people, if they give me enough time, is especially Delaware corporate law, when you really get down to it, it's a distillation of literally thousands of years of people working together and trying to figure out how to work together fairly. It might be one of the more exciting things in the human history, and we're not sitting at just the United States, we're not just sitting at, whatever. It's like, it's a distillation of global learning and like, how do humans collaborate with each other, share things, handle disputes, handle when things don't go the way everybody wanted. And it's, it's like democracy. It's not the best, it's the worst, but it's the best worst that we have right now.
But it's living, so that's the other part.
Yes. Yeah. And it's, I often say lawyers are some of the first developers, because they take a very vague and squishy space of reality and they try to codify it with, well understood structural language, but then they realize like there's always bugs, there's always what we call leaky abstractions, there's always, disputes, and, forever on the living code base of law.
That's probably the most gracious description of a lawyer I've ever heard, Ryan.
Trying to endear myself to them because we work in the same space. So thank you so much for coming here. I hope this is the first of many events together, because tapping into our law firm networks, we couldn't have built and supported Gus Launch without it. While Gus provides a lot of what I would call legal automation, it's mostly for the boilerplate stuff and it's the understanding. But we have a huge partner network of law firms that we work with, because we know every startup needs a good lawyer, and really getting the lawyer at the right time and engaging with them, at the right moments can be essential to startup success, or at least the lack of failure on a technicality in a lot of ways. So let's dive into it. We have a couple polls set up just to get a feeling for the audience's familiarity of this. So I'm going to kick these off. Max, do you want to provide any context? The order I have them in is where you're sourcing documents, the frequency of reviewing it, the thoroughness, and the confidence level.
Yeah, I just want to confirm this is a safe space.
Oh, thank you.
Lawyers, and we focus all on law and contracts. And we think the most important thing in the world. We realize for entrepreneurs, they're not, right. There's a spectrum of that. But I thought it'd be interesting to kind of think through these questions, especially before we dive into the agreement types we're going to discuss, some of those key terms. Just so you maybe feel better with where you are, or you got to help. Put yourself in that spectrum of attention to these agreements. So it'd be interesting to kind of see how business and the legal terms are interacting.
Excellent. And by safe space, I think you mean it's like, you guys are lawyers, but this is not legal advice. None of these people are your clients. There's no retainer or anything in place. I'm not a lawyer, so anything I say is definitely not legal advice.
Right. And it's anonymous. So even if you think you do the worst of the contracts, great, share it. Let's talk about it. But, we won't be able to find you later and say, it's about those contracts you're not reading.
Yeah, so vote in these things
fine.
honestly, because it will help us. So I'm going to kick off the first one. Hopefully this will work. There we go. And so this one is, when you get legal agreements that you're signing, where do they come from? So often somebody leads, it's an email and like, oh, hey, here's the thing. Let me know if it's good and I'll send you a DocuSign, or maybe you're leading with it. If you're a Gus Launch customer, you have plenty of things to lead with. So congratulations.
Yeah, this is always an interesting one too, especially for small companies and startups, because a lot of it comes down to leverage. And, if you're the one trying to get the business, then you don't, have the power to say you have to use my agreement, or sometimes it's always the buyer who gets to use theirs. If it's a very specific service, then I have a very specific service agreement. So some of it's just fun to kind of realize where those differences lie in on whose paper do we sign.
Yeah, and something that we actually leverage, both if you have counsel for your own kind of library of it, or with a launch situation, is often startups do not have general counsel. So if you get an NDA from somebody else, and the onus is on you to read that NDA and understand what it means, or go and pay, counsel to read it if it's whatever. Sometimes I've noticed relationship is like, who shoots first? Like, most NDAs are fairly standard. If you have your own ready to go and you've already blessed it with counsel, and you can actually lead with that, it can save you time from having to go and review somebody else's. All right, I think that's most of the people here. It looks like super evenly split across all three candidates. So we have their agreements, other people's, and about the same. All right, I'm going to end that one. Oh, I can share the results. There we go. Sorry, I should have done that while I was talking to it. Can you guys all see that? Is that working as intended?
Yep, I can see it.
Cool. All right, next up, we have frequency. Whoop, hang on. I have to stop sharing the one poll before I could launch the next one. There we go. The next one is frequency. How often do you sign contracts with no additional legal review? And like Max said, be honest. Nobody's going to trace you down and be like, I see you.
We still have clients that sign contracts that allow legal review. So
Oh, yeah.
that's the legal side on the back end of it. I signed this contract. What do I do now? Well, let's read the contract and find out that is okay.
I weekly ask people, oh, have you done any other corporate actions? And they say, no, nothing. Super clean, not a thing. It's like, okay, great. So you're really basic. And then it's like, well, I did give like 1 million shares to my brother unvested. And it's like, what? What?
I have the napkin. It's okay.
Yeah, the more you walk down the lane, it's very much like just constantly like, oh, well, I filed another organization here. Oh, no, I already have an EIN. Oh, yeah. I gave a warrant to this accelerator that I'm no longer in. You're like, ah.
Yeah, well, it's better to find all that stuff out earlier than later, because half the reason when we're doing a financing or an M&A deal to go through the reps and warranties the company's going to have to make is to figure out what they did.
Yep.
Because half of the stuff probably wasn't documented when it was actually done, and it has to get cleaned up at some point. So it is very much par for the course. It'd be great to be able to kind of keep things moving all the time, in real time, but it just doesn't really work that way in most cases.
Yeah, we always say like expect corporate cleanup at any material event. Like you're going to have to go through the corporate history and fix some stuff. But the stuff that, we try to emphasize with Launch is like silly things like doing board resolutions for agreements. Oh, you signed a safe note with somebody who gave you money, but the board never approved to do that. So you go with a lawyer. When was it signed? Who was on the board? When, retroactive and whatnot. With Launch, everything you can't issue the safe until the board approves it. So you just save those little bit of things. Like there's always going to be cleanup, but together what we're trying to do is reduce that. Because even Jesse and Max are not thrilled, I imagine, going back through and being like, well, who was on the board April 3rd in 2021? And let's draft up a thing and whatever. They would rather talk about your M&A or your funding round or your venture terms or anything like that.
Yeah, I think our clients enjoy that even less than we do.
So these results are interesting. So most of the time, the founders are signing with no additional legal review, which kind of mirrors my anecdotal experiences.
Yeah, and this kind of relates to that first question too, right? If you're usually using your agreement and it's your standard terms, then you really don't need any extra insight because it's already been agreed to one time. I think that's where that balance is. How often are you getting contracts that aren't your standard language, or is your standard language that's been redlined and revised, and you kind of get it, the business terms are still there, so you kind of go anyways. But that's decisions they have to make for the business and avoid some of those hurdles that could slow things down.
Yeah, and I would say good law firms, good startup law firms will provide you templates to use for common, relationships. So you don't need to, get your lawyer to check every single contract agreement you signed out. Like that's good law firms. All right, next up here we have is thoroughness. So how much of the contract do you usually read through before signing? I love me some omnibus
resolutions. Right, I like this 100% came out quick. It's nice.
I have a dream diary full of omnibus resolutions that I just love to read over and over and over.
We'll talk through working with startups, entrepreneurs, small businesses. Contracts are always structured generally the same, with your really interesting parts at the very beginning, somewhat interesting parts in the middle, and a whole lot of standard clauses, the disrespectful miscellaneous clauses that are really easy just to kind of come over and say, hey, look, it's there, and go ahead and sign off without doing a full iteration. I
just saw a comment pop up from Robert. He said he reads 100%, but doesn't mean he understands it, which is also a good point.
Sure.
Because there are a lot of ways to say things that, maybe they are confusing or complex, or maybe they're really not, and they just are written in a way that is incomprehensible or nearly incomprehensible.
Yeah, I think that's targets the goal for the rest of the presentation. So that's you're in the right place.
The like brain unlock for me as a young engineer who is having to sign things like employment agreements and then eventually moving into leadership and signing things and working with lawyers was when they said the term of art, and they gave me like a phrase or something like that and says, what do you think this means? I'm like, well, what it means in plain English. And they're like, it means exactly the opposite. It's just like,
we could thank those Delaware courts for that.
Yeah. So cool. All right. We got one more. And where do we go back? Oh, I didn't share the results of that, did I? Sorry about that for the audience. So 100%. And like Robert said, maybe not understanding it, but that's pretty
I like
solid.
the effort. I like the effort.
And so the last one we got is honestly kind of to Robert's question. So what is your level of confidence that you understand the implications of the legal terms, the legal art? Oh, this is unfortunate. So I put emojis in this one, and it looks like they did not print out accurately in the Zoom one. But I couldn't be more confident is the triumph emoji with like the steam coming out of the face's nostrils. Seems like we have at least one lawyer in the audience for this one. All right, here we go. And kind of as expected, lower on the confidence level at average. Nobody supremely confident. But cool. That's, I think, I honestly think this audience is probably perfect for this topic, which shouldn't be surprising, but it's kind of nice to have a little bit of validation there.
Yeah, and it's great for folks to see that everybody else is in a similar boat.
Oh yeah, there we go.
Crazy outliers we're expected here.
Awesome. So I'm going to let you guys take it away. I'm going to post in the chat right now in case anybody didn't open it. Hopefully that works. That's a funky HubSpot link, but I think it works. So this is the document that Max is going to be using if you want to download it and look at it yourself and you need to get time to review it beforehand, but it's not too long. And take it away.
Sure. Thanks. I got to do the next scary thing, which is try to get the screen sharing up and going. So bear with me. Get that to go start there. How are we looking? Are we full green?
We good?
All good.
Perfect. So I already introduction to Foursquare, so that was easy. Quick agenda. We just did the poll, which is fantastic and quick. Again, hopefully informative for everybody, get an understanding for their approach to contracts and everybody else on the call as well. So I think it'd be great. It's going to be a shorter PowerPoint than usual because the suggestion from Gus, I created that sample agreement, which was started as a Foursquare template for a contract, which was, I think, really good. I realized how difficult it was to make a good contract bad easily. So it's a bit frustrating for practice. So some of the changes in there are inelegant, but being able to do that work ahead of time, kind of think about it before the presentation, hopefully be a little bit invested in that contract itself, and we'll walk through some of those differences. So that should be hopefully fun, and it'll save time at the end for questions, comments, concerns, and then contact info if we can do anything for you in the future. When working with any of the kind of startup small companies, high growth, we like to borrow this timeline that we found. They're all over the place. It kind of maps out the excitement level at the time of what the companies tend to see from the initial startup, where you're feeling pretty good with your entity creation, which is always exciting. Hopefully, there's fundraising that comes with that. There's always some ups and downs, and over time, as your business starts to mature, you'll see these hurdles. And then when we saw this as a firm, we kind of mapped together where the legal assistance impact agreements, they kind of track those things. As you're going through your own company timeline and you feel a emotional or excitement change, good or bad, that may be an indicator to do a quick search out there and say, all right, what should be accompanying this change in pace? And if we do need extra support because we're getting cool things and we need to be able to document it, or if we may be headed towards trouble and we need to make sure you have our bases covered and we're protected that as much as we need to. And this timeline can be a year from startup to an exit event. It could be 30 years. And that means it's really looking at a succession plan, depending on what this company's goals are. But the longer it is, maybe a few more ups and downs, but general arc that we see, and make sure that other entrepreneurs know that they should expect. So as you're looking at that and why you need to pair it to an agreement, we usually boil it down to is anytime there's a transfer of value, you want to write something down, which is a vague way to say it. So to get it a bit more specific, and what you kind of have internal markers for is if there's a transfer of an idea, equity, or money, you should probably write that down. And there's some examples of what those all kind of lean into. Ideas are pretty basic, your intellectual property. And it can be something as specific as a patent, or it could just be business information and an NDA that you want to hold on to as a trade secret. But let's protect that equity. Oftentimes your share grant or a M&A event, anytime that you're letting go something of your company, let's write it down. And the money is a simple one, but that's usually in exchange for the service or the good. I don't think a lot of people are just transferring money back and forth, but it's whatever it's exchanged for is what's really important to your company. We'll make sure that that's documented. And we can talk about what that looks like. Second part is, what kind of agreement do I need? Sometimes it's to, how detailed it has to be. And even as attorneys, we're not suggesting, we don't want every agreement to have every clause or term out there, depending on the nature of the agreement, nature of the parties, the amount of that value that's at risk. You kind of judge where that needs to fall into from what kind of agreement we're working with. If you're having a high-level conversation, a one-page NDA does just fine. But if we're starting to contemplate a business relationship over the next couple of years with $1 million of services or goods going back and forth, yes, we're going to inherently increase that specificity of the agreement. So just kind of make sure you're aligning your expectations of the agreement itself with what's actually being transferred, and that may help set some expectations where they should be. Why do you need an agreement? It's in case stuff happens. Especially early on in the stages of a company, a lot can be done with a handshake. A lot is done by a handshake, and that can be fine as long as everybody's happy. That's why I got into transactional law to begin with, because everybody's making a deal at the beginning. Everybody's happy. Everybody's positive what's going to happen. We're going to give you some money. You're going to give us some stuff, and everybody be along their way. That contract comes in place to hopefully prevent any litigation down the road if something does go awry, which would, again, help determine those remedies without litigation. If somebody breaches a contract or doesn't pay on time, it's a lot easier to go back to a well thought out agreement and say, great, this happened. This is what we need to do to remedy it. It's already in the agreement. We've already talked about it. It's good to go. It also helps working through an agreement if you have an effective template, as from Gus Launch or whoever your legal provider is. It helps walk through some of the aspects of the deal you may not have thought of ahead of time when you're excited working through the business terms of it. You don't always talk about who's going to carry the insurance if something goes wrong. Do I get to own all the work product myself, or is that supposed to be signed over? And so it's really nice to be able to have those questions asked before anything is signed, so you can flesh that out before anybody's vested in one way or another, and have that information handy as the relationship goes on. I think it comes down to accountability before there is a problem. Once there is an issue or something is due, rarely is anybody going to volunteer and say, hey, you know what, I'll take that one, it's fine. So while everybody is still happy and thinking with a clear mind and with their backs not up against the wall, it's nice to be able to chat through those things, write it down, and then at least you know where the other part is coming from if that event does arise.
Go ahead, Jesse.
Just real quick. One other thing in that same sort of the same vein, Max, in terms of like establishing accountability before there's a problem. It could also be the other way around, like establishing what the rules are before something really succeeds. Because if you have, a great success in a situation where you weren't prepared for that, people who were once reasonable can become less reasonable when there's millions of dollars on the table. And so, for sure, when there's a problem, you need to go back and look at the contract, but sometimes success can be, can cause problems. And so, either way, really, you kind of want to make sure you're documenting stuff that's important.
Yeah, I was going to say in case shit happens, there's good shit and bad shit.
Right.
And contracts are not something, I say this all the time, but because founders ask the most detailed questions about like, oh, when I signed this piece of paper or this digital thing, like something's going to happen in the real world, like it's going to self-enforce. It's like when you're an early day, you're not filing these with the government, you're not, doing a lot, you're just signing these contracts and establishing relationships, often to call it like the shell of protection of the company of like what's valuable and what's enforceable. This isn't blockchain stuff. These contracts aren't going to self-execute. Like you signed, a share agreement with somebody and immediately they have, value in your company and they're going to vote to overthrow you, or you signed a safe and you did this thing. It's the thing is, when bad things happen or good things happen, people start to get very interested in the specifics of the relationships that you have with you, and especially if value has been created or destroyed. So it's really good. There is definitely a window or a tolerance of risk for you and how much value you've created already. Like Max was saying, is like sometimes a handshake is totally fine if there's just nothing in the company at all. And you're just kind of like talking about maybe what could happen if you did some stuff. But as soon as you start to do some stuff, you might want to revisit that handshake and be like, all right, like maybe we should make it so that if anybody gets spurned or too excited in some future, we kind of know what's going to happen contractually.
Yeah, it's usually my go-to line, at least me as a lawyer, probably other lawyers out there, what makes me good at my job and terrible at parties is I'm always worst case scenario. And that worst case can be, a good thing, but all right, let's blow what we think could happen out of proportion and just make sure that we've done some stress tests to make sure we still have everything in check. Hopefully it never comes up, but it's worth an extra 5 minutes now to avoid however much litigation down the road.
I think that's actually one of the best use cases of lawyers. It makes them seem scary if you haven't worked with them before, but because they often tilt to this like very much like, well, what would be the worst case scenario for like executing this thing? But that, just like financial projections and modeling and business models, like that's actually a very good exercise for a C-level team to do with each other and with counsel, because it allows you to kind of run, your own Monte Carlo simulation in your own brain about like, well, what would happen if this did succeed? And that can be a very valuable conversation, way more valuable than like, why do I file an 83B election or something like that?
Yeah, I'm talking a little bit later in the presentation, but that comes down to also establishing that risk tolerance. I like to think any good attorney, especially transactional in-house or outsourced GC, never really tells you no. It's just yes and or yes but. So you can do all of these things to make sure that we're aware of the risks and that we're balancing that with the rest of the business model, and that tolerance is acceptable across the board. To start kind of whittling down specifics here as we go from a bit more hypothetical, this is not what your ecosystems look like today. But I wanted to kind of highlight the relationships that most companies eventually will have for their agreement ecosystems, and those relationships where they should be governed, starting kind of over on the left with things flowing into your company, depending on, as pretty general and vague, it's hopefully applicable across the board. But wherever you may have a supplier, a vendor, a manufacturer, if you're a reseller, kind of what that agreement looks like, but call that usually revenue going out of the company and something coming in towards it. We definitely want to make sure that you're getting whatever you think you are going to receive. And the best way to do is write that down in detail with specific terms. And on the other side of it, we usually have hopefully revenue coming in is anybody that is paying you for your services or your goods, your clients, your partners, any resellers, all the other variations that you can have out there. And somewhere in between is making sure that your company is protected when it comes to employees and 1099 contractors, which we'll discuss a little bit today, just from the terms perspective, but making sure that everybody's expectations there are accurate and correct. And then investors, advisors, again, more on the corporate level, the 1 million shares to your cousin. Let's write that down at least and see if there's any obligations or requirements to do that. And then prospects, dotted line, because it might not necessarily be a in-depth agreement in place there, but a good example for even an NDA, where if you're talking to somebody about what your company does or what you could do for them, still a great idea to have something written down that's managing that relationship. So if it helps, hopefully it doesn't hurt when you think about what kind of agreements should I have. This is an ecosystem that is a baseline model, but hopefully gives some context to what's out there. To get down a little further nitty gritty is actual agreement types. And an agreement by any other agreement name is still full of legalese. So these are not by any means steadfast. You have to have each one of these that does specific things. A lot of these can be interwoven as far as what those terms are. But I thought it's nice to kind of arm you all with at least general names for things that you want to have to manage those relationships. Again, if you're doing it with a prospect, the non-disclosure agreement covers it. If you're in software and use license agreements, really do manage kind of what they can and can't do with your software. Operating agreements, everybody probably should have one of those, even if it's a single member LLC. So that one should be pretty applicable across the board. Again, the more complex your corporate structure is, more complex the operating agreement it gets, but that's something that can also grow and change with that company. To your point about doing corporate cleanup, document cleanup, that works with contracts as well. That's what amendments are for. That's what restated and revised contracts are for. So even if it's a little bit more work up front to change them, it's a lot easier than staying with something static that's no longer applicable and having to go back after there's a problem and try to figure out what was going on. Again, these kind of broken down into those 3 pillars of value. So you can want a good idea of what your transfer of value for idea would be, or equity or money. These are just cool ones to have on the tip of your tongue and say, hey, this is a supplier. Maybe I do need a supplier agreement. The one that gets a lot of people tripped up, actually you want to write a blog about it for our website later this month, is putting the term master in front of any of these, because everybody likes to request an MSA because it rolls off the tongue so nicely. And any of these most of them can be some kind of a master agreement, but there are particular use cases for those, and they can be more problematic than not. So I want to make sure that as you're thinking through what you're trying to accomplish with your agreements, you're not locked into the staples that you've heard: an MSA, an NDA, and a advisor agreement. There are a lot of different categories out there. And if you're not quite sure, talk to an attorney, reach out to the resources you may have and say, hey, this is what I'm trying to accomplish. It sounds like it could be supplier agreement, but we're going to have some distribution in there as well. What do we need to wrap that into? And then a good attorney can call it the agreement whatever they want to, as long as all the obligations are kind of stipulated the same way.
And for I think I know this, but an operating agreement in the case of like a Delaware C Corp would often be more like the bylaws that you adopt.
Correct.
Yeah. You would, operating agreements are sort of, I guess you could call something an operating agreement, but for the most part, an operating agreement is the central document in an LLC. But a corporation is going to have the charter, the bylaws, other agreements between the founders, maybe a stockholders agreement, but it's just a different set of documents, basically.
Yep, good highlight. Get even more granular, and I want to go through this a little bit quicker than usual, because a lot of these were actually highlighted in that example agreement. But as I mentioned, usually I break down any contract into 3 categories. The first 1 to 3, 4 sections, usually where the fun business stuff lies. What am I getting? Who am I paying? How am I paying it? Am I getting paid? And that covers a lot of the needs for an entrepreneur or a small business, which is where a lot of times, I think we kind of saw it in that first poll or third poll, a lot of people stop there, which is fine. At least what you're supposed to be getting and what that consideration is going to be for it. The second category, an official name for it, is additional obligations, are usually longer terms that have to accompany those business terms to make sure things go okay, or that everybody's comfortable with that relationship. Yes, I will pay you this, but here are some extra clauses to make sure that I'm getting what I want for the money. Or yes, I'll provide you services, but for me to do that, I want to make sure that you're providing access to this, that, and the other. And if something goes wrong, there's identification that if I'm sharing this information, great, here's all the confidentiality terms that we want to have to make sure that I still feel protected. And then that's usually clauses 5 through 10. And then 11 through 20, standard clauses, miscellaneous clauses, are usually pretty short in length. So they look really harmless, but they can be really impactful if a couple of words are different. I have some examples of those. And that's why I'm always interested in, how far do folks read into an agreement usually? Trust me, I know it's difficult. I get on page 60 and I'm still trying to slog through it. And seeing these headers are great. Perfect. We have a venue and jurisdiction clause. And a lot of times this is great to say, perfect, we got that clause in there, we're good to go, without reading those 3 lines and saying, oh, this is actually have a really big impact if something goes awry, to get these right. Force majeure, especially after COVID, everybody's signed a contract. Yeah, it's force majeure, we're fine. the government shut down because of the pandemic, and there was a huge rush of folks going back to the contracts and saying, is pandemic in there? Is epidemic in there? Is that active guy? Is that government? So 434 got ignored for a long time, but became really important really quick.
I think that's actually a great illustration of where we're going in the next who knows how long, but a lot of clauses and terms that have existed in, you know, common agreements that haven't mattered in a low interest rate environment where money was cheap and valuations were increasing and things like this. I think there's been some great Twitter threads over the last year about like, have you heard of full ratchet anti-dilution? That has never been in any terms in the last 5 years, but all of a sudden investors are seemingly interested in it. It's like, oh, because down rounds are back or something like that. So there is a good reason to use time-tested things. I've even heard of people being like, I actually like convertible notes more than safes now, and I think I might use those more. So well-tested, time-tested contracts sometimes have a bit more of a longer history of, you know, things when times change.
Yeah, again, it's what's happening in the times. You know, back in the 90s, nobody was really studying impeachment law because it hadn't happened in so long, and all of a sudden, the one person that wrote an article that got published about impeachment became the go-to interview because it's coming back up again. So some of those things do get less attention as they move on because it becomes an assume that it's fine the way it is, but let's make sure we're keeping eyes on. So common hurdles with those terms. I'm sure you guys are familiar with them, but we can kind of chat about what they are and then, you know, hopefully ways to diffuse it. Some is just legalese, and maybe I'm a new age attorney, but I see it now all the time. We get so far into now heretofores and notwithstanding the whatever it may be, and it looks like it should be 4 different words, but somehow it's one. It is complicated, and you know, you have the ability, if you're engaging your own counsel or looking at agreements, to say, you know, let's just drop all that. Yes, we may be losing 0.5% of efficiency, but if you can't read it, it's not helpful. And you may, or your other party unknowingly, browse over something that was really important just because it was a pain to read, and that is true. Terms of art, as you mentioned, is really tricky because they look like English, but they're not. And there is an example in the contract. We'll see if you might pick that up. Usually the warning sign there is if it doesn't read like you would say it in conversation, it probably doesn't mean what you think it does. You know, which is hard to differentiate between term or legalese, because that doesn't sound right either. Usually it's more of that statement of, would I have said that to somebody if I was just talking to them at a restaurant? And if it's not, at least flag it, do a quick search to make sure that it's okay. Capital words get tricky because they're all defined, and it's super easy to define one word 4 pages ago that does not mean what you think it is later on. So capital words, if you see those, just, you know, one extra light that goes off to say, let me double check that means what I think it means and not just assuming it. Hyperlinks and incorporate documents, you can get a 1-page agreement, but it can be 90 pages long of hyperlinks somewhere else. And it goes, oh, by clicking this, I agree to a privacy policy. Great. I'd say 70% of the time, either that privacy policy didn't get read, or it's not a static agreement, especially if it's an active link, because you're agreeing to it and it's then current term. So you have to kind of keep checking that on. So really encourage folks, if there's a hyperlink, copy, paste it, put it in an exhibit. It's so much easier for you to follow. So that's always a fun one as well. Other hurdles of practical application. It gets really difficult. It can be really difficult to think about legalese first and then digest that into what can happen with the business down the road with those worst case scenarios, best case scenarios, whatever it may be. So it's really worth that practice to sit down and think about what would happen if termination is a big one, either side terminating, if money's already on the table. Just walk through, would I get back, would it make me whole and the company whole, or would I be overextended too much to not do that? And then second, number 2, apparently, is that risk profile, and realizing that, you know, the terms of one agreement may not be in your favor. It's okay if all your other agreements are in fine shape, but if you start, you know, bank rolling some or stockpiling some bad agreements and they start going wrong, you know, your risk profile is out of whack and you may not be in a good spot. we also want your risk profile to be so limiting that you don't accept anything but the most perfect terms, is that way you actually may not get business at all, which is just an opposite kind of problem. I did see some questions popping up, and this is a little bit out of sync because we're going to cut over to the agreement. But if you want to do a quick questions, comments, concerns break, Brian,
I'll get a couple of the quick relevant ones. Ed just asked a good one right off of what you had, is does adding master to an agreement have any implied legal meaning? Does it add some kind of obligation just by being there?
No, it's not an obligation per se. Usually a master agreement means that you anticipate doing multiple similar agreements with the same parties. So rather than doing 8 different services agreements that all have the same legal terms, that you could have modifications throughout the years, you want to take all of those standard terms and really those obligation terms, put that into one agreement, assign it one time, and then you're really kicking off task orders or statements of works that say, hey, I want this many widgets for this much money delivered by this date. And for all of the legal terms, look at that master agreement. That's where that stuff lives. And you keep doing that. So it gets really easy to do repeat business. And it prevents you from having contradicting terms, where if you do net 45 on one contract, 6 months later, you decide to do a net 30, 8 months later, you do a net 60. And then you're trying to figure out, well, what did we really do here? It just gets really complicated. So that's where the master services agreement really helps out. The other impact it does have, which is a con, is usually when an organization sees a master agreement, it ratchets it up the approval scale like 2 or 3 levels. So rather than a department head saying, here's a services agreement, it's just this one time, it says, ooh, this is a master services agreement, and for the next 5 years, these are the terms that these companies are going to have. And all of a sudden that level of approval goes up. So it could slow down that business if all you really are anticipating is a one-time transaction.
It's a great answer for that. We got another one for this slide. David Alicia asks, Foursquare, can you work in any given US state, or are you guys limited to a certain handful of states?
So I can take that one. We are not licensed in every state, but we do have clients, probably not in every state, but we have clients all over the country. Most of the time, those clients are Delaware corporations, and we are licensed. I'm licensed in Delaware, so we usually get comfortable with that. And depending on what it really kind of depends on what the project is. If it's a financing or an M&A transaction, we definitely can do it. It's not going to matter what state it's in. But if it's something like an employment issue, we probably can help, but we also might want to get an employment lawyer that's, working in that particular jurisdiction every day, just so we check. And that's kind of how we play that role of outside general counsel. So we'll handle the stuff that we can handle. And then if we have things that are outside of our scope of expertise, or for some reason we're not comfortable working in a particular jurisdiction without someone who's licensed there, we'll bring them in.
Yeah, so it comes back to.
Go ahead. No, go ahead, Matt.
So it comes down to where we get into the governing laws of the contracts. We have licensed attorneys, Delaware, New York, North Carolina, California. And so we're familiar,
Virginia.
Pennsylvania.
Yeah.
So we're more familiar with those laws and governing laws of the contract. Where we have a problem is if somebody wants to agree to terms of a contract governed by Texas law. That's the Wild Wild West out there. I don't know, and so we'll kind of draw that line and say, look, who we're working with. Most of the time, wherever our clients are, if it's their governing law, or Delaware, which is the best governing law to have because their case law is so robust, or New York law because your international business law there has the same kind of case law behind it, makes it super easy to work with. But just his point, if it's something that could be getting on litigation, including employment issue, you always want to find somebody in your state that is familiar with that state law, if not the jurisdiction where the courthouse is, because they're going to have their specific court rules of procedure.
And I will say, because I know David is a Gus Launch customer, if you're a Gus Launch customer, you can find Foursquare through your Gus Launch portal, or just ask us with the support team for the introduction And because all Gus Launch customers are Delaware C Corps, usually you guys can probably help them out.
So someone just mentioned in the chat, and I was actually going to say this, but then I decided not to. If it's Louisiana, just find somebody in Louisiana.
It's the space chicken from Futurama. That's the best.
Exactly. Yeah, you have 49 states that are the same, and then you have Louisiana. So,
all right. So we have some other good questions, but I'd love to jump into the document. Do you guys have a hard stop at 4, or can we go over a little bit with this?
I'm up to your discretion. I can try to crank through as fast as we can. I can take the time. So it's a matter of how we want to delegate it. Feel free to put a clock on me and just let me know, and I can.
Yeah, let's. Some of these questions are pretty great, so I would like to return to them. But since we sent everybody pre-work materials and you spent time trying to make a good contract bad, I'd love to jump through that, and then we'll return to some of the questions in the chat if we can go over by maybe 15 minutes or so.
Yeah, absolutely. Let me try to switch the screen share again, so we'll see how well I do there.
Oh, and I will grab a link to this again in case anybody missed it. I just threw that in the chat.
Is that document up?
Yep. Yeah, I can see my company consulting agreement.
Perfect. Do not send, because this was going to be the cheat sheet. Okay, so this is where I want to have I was trying to do like a really creative poll of, how many things did you find wrong? Would you do this now or then? But very easy to orchestrate. So I'm just going to go through the agreement. You can be honest with yourself if you thought it was a problem or not. And then again, if you want to load up the questions with any clarifying things, or reach out to us later after the meeting, feel free to. We can dive into more detail. So as we talked about, the first couple of sections here, right? Engagement services, super interesting. Compensation, really interesting. That's where the nitty-gritty gets outlined. Back up a little bit, as a consulting agreement, this also has the extra layer of, are they an employee or not? Which would be really nice to say, I'm calling a 1099 contractor, so they are. I'm calling them an employee, so they are. Unfortunately, it's not the way the EEOC sees that. One of the things they look at with the contractors is a list of evaluators, is that contractor consultant in control of their own work. And so let me do this well. If you want to say that the company's in control and direct that consultant, that's going to be a flag from the EEOC saying that they were designated as a 1099 contractor, and they should have been subject to all of the rights that an employee would have. You should have been, withholding tax information or tax amounts. So to make sure that for any consultant, you're not in control, you can kind of give them the task at hand and say, this is what we need to create. But if they want to do that at 2 o'clock in the morning, cool. You want to balance that with their projects, great. You really are limited to what that deliverable is, as you guys have kind of highlighted that.
Yeah, that's an issue that has been a hot button issue forever. And especially at the earliest stages of a company, it's cheaper to hire people as a contractor. You don't have withholding obligations. It's simpler. There's a lot of reasons why you would want to structure
no minimum wage, no unemployment tax.
Yeah, exactly.
State by state filings.
Right. But and frankly, a lot of times that's kind of a risk that companies take, but really what ends up hurting them is that they don't go back to fix that, and they let it run for 3 years, and then somebody has an argument with someone they're working with and they get upset, and then the next thing you know, they're going to the Department of Labor and saying, I thought I was an employee this whole time.
Back wages or
right, exactly. And that's a mess that you don't want to open.
Yeah, and the conservative rule of thumb is the EEOC would never try to convince a W-2 employee they were 1099, right? It's never go that way. So the safest route is to defer to a W-2 where they have those protections and scale back and say, well, wait a minute, this really is a contractor. If you really don't know and you're really worried about it, nobody's going to argue that they were really a 1099. No, sorry, W-2 when they were a 1099. I think I did that correct. Going on to compensation, you get really bogged down in all these details, but it's really important to think about what and how you're paying for something, especially with consultants, being able to outline that while it's great to pay for their expenses, this gets super detailed and needs to be pre-approved, need to be outlined in the original estimate as well. They use some language like anything that's reasonable, but anytime you're going to be paying for something outside of what that number is on the statement of work or the task order, just make sure that we're detailing exactly what that process would look like. Disputed invoices also comes up a lot, and if you're going to have a caveat that all undisputed invoices are due within 30 days, let's write a process for what a disputed invoice would be. That way we're not caught for 6 months saying, well, no, it's still in dispute, right? Let's put a timeline. You have 30 days to resolve it. It's not resolved in 30 days and this happens, and figure that out. But the more detail you can get in here, the easier it is to make sure you're getting paid what you think, or only paying what you anticipated, and you're not getting a bill down the road that
so this is a contractor. If it was just as loose as consultant will be reimbursed for expenses and they get spurned, or they're just crafty or whatever, they could be like, oh, here's my gas mileage, and here's the heat for my house and the room that I worked out of, and like here's a whole ton of invoices for things I need to be reimbursed for.
Right. Even if they're not even necessarily spurned, necessarily do business, and they thought that those would be included because that's how it worked in the last 3 companies. Let's level set some of those things so it's not a surprise down the road. Ownership of work product, maybe sneaky, maybe it wasn't that sneaky. Switching out who was going to be owning that work product, and depending on this is the contractor agreement or the agreement you're working with, it may be that the consultant really does own that work product and they're licensing back to you. But this is an example where changing the same word 3 or 4 times really shifts the value of that contract. And if they are going to own the work product, great, but let's pay them less money for that license. Make sure we're including that information in there. But anytime there's work product, anything that can be tied to IP, ownership of that, regardless of what the service is and the compensation is for it, let's make sure it's ending up and staying in the right hands throughout.
I think this is really important in startup land, where often startups are working with other startups, and a very common startup like bootstrapping path is to offer consultancy and contracting services to pay yourself while building something that you use to render those services. So you might work with an ad agency who's also like building some really cool backlinks, system that they can resell to other startups later in the future, and just having clarity around like, well, all the ad work they do for your business should be owned by your business. They should not walk away with your ad accounts or whatever that they have. However, you want to be clear that like, oh, if they do have something, and it's totally fair, right? That's the fair thing to do, but having it spelled out rather than bizarrely if you're a company and all of a sudden because of the contract you sign, you're like, hey, we also own your backlinks thing that you made for us. And then on the flip side, so that, you don't actually not get the full value out of the arrangement.
Sure.
Yeah. And that can be, okay, you're going to get into, the pre-existing IP piece is, this is relatively simple language because we need it to be, but that whole concept of what existed before and what is retained by the service provider and what is being created for your company, that can be very complex. And so that could be a whole other Zoom call if we wanted to do it. There's a lot that can go into that.
We're working with software companies, anybody who's doing developing, they're doing a partnership of that. It can be all fine. Let's just make sure we're drawing the clear line of ownership, what's included, what's not. We'll do whole attachments of outlining what IP is included or not included, what's being retained. Yes, before Jesse jumped the gun on me. Making sure
but that is a good idea for some future programming, because the number one reason we push people to our legal network, after they get through like initial governance setup and stock grants to the founding teams, and they come out and they're like, IP, trademarks, should I do this? Should I do that? And it's like, we've got a founder IP assignment that is basically just for the founding team, saying like, hey, all the stuff you're working on is owned by the company, short and sweet. But as soon as it comes to anything else, it's like, you need to probably talk to an attorney, because it's usually just not cut and dry standard templates that you want to use.
Sure. That comes down to licensing too. And this is just an example of a grant of a license. And usually when you start reading, or I start reading, conditionally, irrevocably, sublicensable, not sublicensable, can't transfer this. It's like, oh, yeah, those words are in there. But, you know, just a quick switch of if it's conditional, unconditional means that it can go away tomorrow. Revocable versus revocable, that can go away, which is okay if that's what's intended, but you'll make sure we're not glossing over those kinds of, you know, string of legalese and going, yeah, there's a license in here, great. It really does pay off to read through those and think about, do I want this later on? If they revoke it, what does that mean? Do I want them to sublicense my stuff? I mean, to say it's not sublicensable, and really pay attention to those words. Jesse's point again, pre-existing IP depends on that project, but you definitely want to make sure that we're protecting or understand what you're not getting if it's the other party's pre-existing IP that they're going to hold on for themselves. Reps and warrants. This is a little bit of legalese. Sometimes it is vague. You see things like best efforts, reasonable efforts. Depending on what side of the agreement you're on, you either want to really zero in that it's going to be, you know, professional manner, industry standards, especially if you have specifically stated in the statement of work what they're going to be doing. So make sure everything they're going to be doing lines up exactly with that. If not, I'm going to warrant to fix it. If it's your contract and you're providing it, you would love to say, I'll do my best effort to do this. And if it doesn't, well, sorry, I give my best try. But that's part of the contract, and it kind of depends on which side of the agreement you're on. This is a quick flag, especially working with software, that keep an eye out for open source software licensing, because they have a few nuances in there about what you can and can't do. Without saying it necessarily, sometimes it will call out open source software if it's included in a solution somewhere else. Otherwise, keep an eye out for like GNU is a pretty common one that you go, oh yeah, it's an acronym, it's fine. But just be aware of those open source responsibilities, because they do have restrictions on being able to generate revenue from it or sell it, or if you're going to reuse it, you know, copy left to make sure that all the attribution is still there before you get in trouble.
Yeah, as a software person, the GNU or the new software license, there are ones where basically, like, if you build derivatives off of it, you have to also make them publicly available. So if you're getting private company benefits, you're, you know, creating trade secrets or corporate value, and it's coming from a derivative and open source project that has that kind of license on it, you might basically be giving away the special stuff that you built.
That language is, there is a rep in almost every single VC or M&A deal where the company has to make a representation that none of its software code is based on one of those, you know, copy left licenses. That's a really good point, because that's not something that people tend to think about, especially at the very beginning. And a lot of stuff, the initial version of it anyway, is built off of that type of open source license. So that's a very good point.
Yeah, and don't get too spooked if you're building a custom application that uses a GitHub library that's licensed under that, and you don't change the library, you just use it as public and you don't contribute it to it. It's not like, oh no, all the custom stuff that I built is now owned by this, you know, maintainer of the library. But I'm a software developer. We do things called monkey patching. We do things, you know, where we literally have to like go and kind of like tinker around with the thing. And if you're really not comfortable, or if somehow, you know, your engineers are likely not brushed up on legalese and realize like, oh, hey, we can make a copy of this and just like integrate it into our application so we don't have to deal with dependency management. It's like full stop.
It's like the, was it Jeff Goldblum? They've been too busy wondering if they can to think of stop to think if they should.
Yeah, shoulders of giants. Well, I don't know if you've seen the XKCD comic, but it's a huge set of blocks of a massive structure, and it's like all the enterprise software in the world, and then down at the bottom, keeping it all standing up on one side is one tiny block, and it says one library built 20 years ago, maintained by one developer who is now like losing interest in it or something like that. Like, that's
gotta track this back.
Software.
So back to independent contractor a bit is the concept of agency and making sure that you're restricting what that contractor is allowed to say they're doing on your behalf, because there is, even if you did not approve of their entering into a different agreement or making a promise, if the other party didn't know that it was a separate relationship, you could still be bound by that one. So make sure that we're really drawing that line between them and you, and you're protecting what you're responsible for down the road. So it's really hard to change our really good confidential information section. So I just deleted something at the end that I think is pretty important that gets left off half the time. But it's a concept of if you're being legally forced or asked to provide the confidential information, that you include that clause out there. These are all pretty standard. What is or is not confidential information. Some variations of like, is it need to be marked as confidential or not, or is it assumed confidential under the way it was disclosed? That's fine, and there's nothing that's wrong. What we want to do is make sure that if there's a court order and you have to disclose that, you know exactly how and to what limit you can do that, and also allow your contractors to do the same thing. So that's also something I kind of keep an eye out when I'm even doing an NDA is, yeah, I'm not going to disclose this, but if I get a court order, I'm also not going to be acting against the judge and in contempt of court because of it.
Thrown in jail for refusing to, yeah.
Right.
And if you build a oh, go ahead.
No, I was just using bad contract terms. That's not great if you end up in jail because you're adhering to your business contract.
And people don't think about it, but like if you're building a software company or company that's going to have customers, like you will probably get a court order at some point. If you have thousands of customers and somebody completely unrelated to you is fighting and you're disagreeing over a thing, sometime they're going to subpoena you or do something to be like, hey, you've got information necessary for this case because of the software you provide. And
Right.
You want to be sure you
Especially
know.
as a platform.
Yep. We help accelerators, angel groups, and founders. So it's like every once in a while, you just get something where somebody's fighting and you're like, you created a Gus profile 12 years ago and applied to like an angel group that doesn't exist anymore. But for some reason, the lawyers are like, there could be something in there.
Yeah.
Good to know.
Those lawyers. Ooh,
man.
Somewhat related, when they get confidential information, the whole concept of need to know, which is, I don't know the term of art because it's kind of a weird thing just to say. Make sure that everybody's going to see your confidential information, especially if it's trade secret related and it's not protected by a patent or anything else, that you're limiting that disclosure to those who need to know, that are also subject to confidentiality terms, as strict, if not more strict than what's being signed here, but follow that funnel down of like those confidential responsibilities.
Is that like the case of you consult with a contracting firm and they're like, oh, we're just going to take everything that Gus sends us and upload it to the local drive that's accessible by every employee in this massive thing, and like anybody could go and download it. Maybe they're helping our competitors, whatnot. It's like, no, you want the protections to say, hey, like only share this with people in your company that are actually like working on it.
Right, for two reasons, right? One, the project team actually do need to know that, and they're aware of the situation, and it's easy to figure out, are those folks under some sort of obligation or agreement to keep that confidential, as opposed to Linda in her county who's just kind of was cruising through a document and said, that's really cool, and didn't even know that was supposed to be confidential, but then goes shares a trade secret about how Coca-Cola was made because they didn't know we weren't supposed to do that. I think a few that were remaining in here. Non-solicitation, non-compete. Again, that's a whole other hour and some odd presentation. There's kind of some general reasonable terms there. 3 years, or sorry, 3 months is like way too short. You can get that into a year. 6 months is kind of okay, but anything more restrictive than a year is tough to do. Anything less restrictive than 3 months isn't that efficient, especially at a startup, high growth company, when you really invested in your people and your clients. The more you can protect that, the better. But as you've seen, some of those restrictive covenants are coming under fire from state legislatures and what's actually enforceable, which, as we discussed before, this one was a whole other opportunity for how to interpret and enforce those.
Yeah, we put limits, I think the maximum you can do our NDAs are 5 years, because state by state law, it's like, it's almost impossible to create a contract that would be held up in every scenario. So like you have to put some reasonable limits in there. Otherwise you can't be like forever until the heat death of the universe.
And there's no harm in trying, right? If you can put whatever you want in that contract, if it gets questioned, you could be okay. You don't build your model and risk tolerance off of, oh, we have this confidential for 10 years, we're good. And then a court says, nah, 2 years is enough. And you're like, okay, now we got a problem. Successor and assigns. This is really transferring the agreement for a variety of reasons, which varies between parties in the contract. If you want to have a service provider that can transfer it or not, limit it, that's reasonable. What we really want clients to focus on is making sure that they can transfer the agreement if there is a merger and acquisition, right? If you've got a long-term deal with a client and you're about to be bought by somebody, part of that process will be looking at your major contracts and seeing, can we assign this sales contract from one person or one entity to another, either just with notice, or do we have to get permission? Can that permission be unreasonably withheld? Is there a contract at all? Which is always terrifying to find out there's not. But what you don't want to be is limited to, your business's next step because you're confined by your contracts that they can't be transferred for any reason whatsoever. This is our awesome term of art clause that I try to sneak in here because a lot of times that's how it happens. Saying time is of the essence is one of those things, like, it seems kind of obvious to everybody that this time is important. It's a really weird way to say that. And what this 1, 2, 3, 4, 5 word little clause here opens up a ton of damages if something is breached. And it really allows the other party to hold you to performance on that certain timeline. And if not, you can be responsible for liquidated damages, anything that was missed by that client. If you're supposed to supply widgets and there's a resale, all of a sudden you're responsible for that loss as well. So unless it is a true, usually it's in construction where there's a time date you have to hit, let's just avoid time is of the essence at all costs. Is that rule of thumb. Governing law, we did touch it a little bit. If you see Delaware in there, you're always good. New York, usually good. If it's your home state, check with your attorney. That's probably good. We see a lot of folks, as I'm doing work with somebody in Texas, they want Texas law. I shouldn't say this one. Think about governing law as if like advice from the in-law. Like, would you take that or not? South Carolina, probably not. Louisiana, they're a little bit crazy. My in-laws from Texas, they try to tell me what to do. Maybe not. It's not the most politically correct approach on it, but it's not inaccurate as well. California, God bless them. I don't know what's going on in that part of the country. Let's stick with what we know, or get confirmation from an attorney, right? Those are the states that you don't want to just blindly accept, because there could be some crazy stuff in there. Either to get it to a neutral, known entity like Delaware, like New York, or your home state, if you've been able to check that with an attorney. And then related is going to be your venue, which is mostly part of 1, convenience, and 2, bias. If you're not in Texas and you're agreeing to go to Texas to sit in the jury of peers, and the other party is in Texas, you're already losing to the home team a little bit. If that's going to be 2 connecting flights to get to some small town to get there, time consuming, expensive. Let's just meet in New York. Everybody get there direct and figure it out there. Those can be different, right? Governing law and venue can be different based off that convenience and home court advantage concept.
I think that's one of the ones where it's like, if it's going to change, like there should be a reason behind it. And there's also some like research, like we got sued in a patent troll lawsuit like 7 years ago. And they argued like hell to get it changed to the Eastern District of Texas, because apparently there's very patent troll friendly laws there. And so we're a New York based company. We've been a Delaware C forever. And, most of the fighting on the trial was just to relocate it, and it's like, why? Oh, because they know that there's sympathetic courts to whatever they're trying to do. We got it pulled up to New York and we won that case. But like, that was one of those cases where nothing in our contracts said anything about near Texas. We didn't have any employees in Texas. We didn't have any operations in there, et cetera, et cetera.
Yeah, and this is usually the first fight in the litigation. The more you can write that down and make it clear, the better. If there is no governing law clause, then you have to fight, and that's just part of that step. So again, this is a 5-minute conversation that can save you 3 months of litigation. And I think real quick, the last one, just waiver. Again, it's not even a full 3 lines long, seems really simple, but if you change this, a breach of the provision of the agreement by consultant shall be construed as waiver versus not, really means that if they did one thing wrong and you chose not to enforce that against them, you've now restricted yourself from enforcing any other clause down the road. As opposed to, as written, if you don't want to or forget to enforce one late payment, if they do it again, you still have that option to do it or another clause in there. So it kind of says, you breached this agreement one time, the agreement's been breached, that's all you have to do, Abby. So again, just an example of getting into the nitty gritty towards the end. Almost no tests that end game of section 20, but always important. So that was a bit of a fun tester experience to run through. Just to finish it out, this is kind of a standard project assignment, right? Anytime you're doing a agreement that refers to an exhibit for those sections 1 through 3, just make sure everything aligns top to bottom, right? If you're going to defer to pay the fees in exhibit A, just make sure that all those fees are really well thought out, include expenses that are pre-approved or anticipated. But this will be really, really specific per company and what service is being provided, but you want to have something in there for sure.
And we advise with, some of the agreements we've designed in Launch is to not try to put the ultra specifics of like the day-to-day into legalese, but rather allow it to be deferred to like an exhibit or a scope of work or even follow-on communications, so that you're not having to like relitigate the contract as things change all the time, because things are uncertain in a startup. If you hire somebody to do tech work, web development, what you don't want in your original contractor agreement is like, the colors of the things that they're going to deliver, like what kind of code they're going to use, this and that. It's much more like, this is the scope of work, and like we can use other means of communication to like evolve this and keep working, but let's keep the relationship well contracted with all that other stuff.
Right, especially if you use the same agreement for different clients, and it could be a bespoke service or good you're doing that. You don't have the freedom to be able to change that up without having to go back and make sure you've caught everything in the agreement.
Yep.
Okay, that was a lot of me talking. We can go back to questions, comments, concerns, and contact.
Yeah, thank you for your extra time. And that was well, we're all poisoned by now, so like that was fun going through and seeing like the opposite sides and the different kinds of languages. We got some great questions in here. We're going to go all the way back to Mikaita, who I don't know if we'll actually be able to cover this, but what are the key sections to consider when drafting call option agreement for employees of a startup? Call options, that doesn't actually ring familiar to me in terms of early equity. Might they just mean stock options?
Could be. Could be. I mean, a call is usually somebody's right to like buy something from somebody. So I'm not sure off the top of my head what exactly that call option is, but I mean, when you're issuing stock options to employees of a startup, I mean, the vesting is super important, making sure everybody understands it's either time-based or it's based on milestones. If it's based on milestones, it needs to be very specific to whatever the situation is. That's probably another thing we could do a full, full thing on is equity comp. But
I think when adopting an option plan and then actually issuing options, like that is an entire corporate event. You need a director approval, you need a shareholder approval, you have to designate, how many options are in the option pool, you have to adopt powers and grant documentation and things like that. So we do include that in Raise of Gus Launch. We have a very nice, employee incentive plan or equity incentive plan. But if anything gets more custom, like, and if you're not on Launch, like you need to work with an attorney to adopt a stock option plan, and they will walk you through like the things to consider. And then, like Jesse said, individual grants, vesting is the number one control companies have over ensuring that things don't get really messy with ownership. Here's a fantastic question. Finally, having a lawyer to answer this rather than myself. I am bootstrapping, so I've been hesitant to get a startup lawyer. Can you give us an idea of what we should pay a startup lawyer, especially through the fundraising process?
A lot.
It really depends on what we're talking about for fundraising. I mean, you can, a lot of times we see the earliest money in is a safe or maybe a convertible note. Safes in particular are usually very simple. Like you're talking about, probably sub $5,000 total, like all in kind of documents together, everything's closed, securities filings made. it could be more than that. Depends on if there's negotiation or stuff like that, but that's probably the cheapest. I mean, if you're talking about, like a Series A, which tends to be probably the most intense financing event because you don't really have any of those documents yet. I mean, that can range anywhere from $30,000 to $75,000. Probably depends on a lot of different factors, but it can be expensive. But it can all, I wish I had made this up, but I didn't. If you're worried about, what's the quote? If you're worried about how expensive good lawyers cost, you don't want to even think about how expensive bad lawyers cost.
Yeah, because you're going to pay that not in the legal bills, but in somebody else's legal bills, the good lawyer's legal bills to fix what the bad lawyer did.
Yeah. Or you just totally mess yourself up, and that just is infinitely expensive.
Yeah, you can contract yourself into the ground, out of business, basically. Right. I've actually seen a company, not a Gus Launch company, but I've seen a company try to get an unqualified opinion to do a Series A like round, and a law firm quote them 6 figures of corporate cleanup. Just being like, we won't touch this unless we literally walk through your entire corporate history from the beginning and ingest everything you've done, and it's going to be crazy in hell and things like that. And if you're raising $500,000, like that's a huge chunk.
Yeah, it's pretty hard to swallow.
And one thing I wanted to put on this, in terms of the real value, like you mentioned securities filing, and this is something that I think founders just never even think about doing. I've seen people sign safes, they pull off YC's website and be like, I raised money. Not alone did they not do the board action, but they didn't actually be aware of it. The strategic conversation is most important. It seems ridiculous. Like a lawyer is not going to go and come up with their like custom magic dusted safe that they're going to get for your pre-seed round and whatnot. You're not paying them for the safe. The safe is out there in public consumption. What you're paying them for is the conversation around like, hey, who are you accepting money from? Are they an accredited investor? What state do they live in? Do we need to file some kind of securities exemption so that you don't violate securities law and these kind of things? Is it smart to take money from this individual based on the stuff that you don't know? And that stuff can be invaluable, but it's not like you're paying for the 3-page safe document, just from the custom law firm or anything like that.
Yeah.
All right. Oh, this is a great one. How effective are NDAs? So like if you're having, you're trying to get pragmatic protection against information being shared. If you're talking to somebody at a bar or like people mentioning it, like how effective can NDAs? Who should you be asking to sign NDAs and what level of conversation?
Max, you had an input on that one?
I do. I always think NDAs are extremely important, if not that effective. The practical application is, I think they set a tone in the business that this is not supposed to go anywhere else. And if somebody has a problem signing that NDA, as a litmus test that we should be sharing this information, which is great. You just share it without anything that's going to be confidential or trade secret, or that could rub you the wrong way. So I think it does help set the tone or expectations moving forward. How effective they are to be held up in a court, you have to ask the litigation attorney on that one. I don't know. They are something, which is better than nothing and just having it go out the door. But you start getting into, especially what you're discussing, if it's something that's patentable and somebody swipes and gets the patent first, the NDA just becomes kind of moot. So it gets ugly. So I always encourage the use of NDAs. If they're mutual requirements, usually they're not too burdensome on either party. But I don't know how much gusto you want to have behind you threatening somebody of this NDA. But it is important to have out there.
I think one interesting thing is don't try to get an NDA signed for anybody that you talk to about your company whatsoever. Like usually what you could share in an elevator across a bar, you're not being like, well, these are the detailed, algorithmic choices of the patent that I'm filing. If you're pitching your thing to a startup, do not send NDAs to investors. That is the number one signal that you are a naive and unsophisticated founder, and they will say, hell no. I look at hundreds of companies a month, if not more. If I signed an NDA to every company, I'm not being bound by that. Pitching your company, sharing your idea, scream it from the hilltops. Most people just don't care. The more people you can get to care is good. However, NDAs are most common between vendors and other entities where it's like, in order to do business, I'm going to share information about the state of my company. And like, I don't want you to like sell that or use that, sell it to my competitors or use it strategically. Everybody's kind of competitive. We use Stripe to accept payment processing. Stripe has a product called Stripe Atlas that does incorporation. Like if I was going to go and use Stripe and be like, are you going to peer into my account from like the strategic level and like figure out the state of my business at any time? It's like, no. But also the NDA coverage is often in other kind of agreements. So it's like, I don't think you want to paper, like if you bring on somebody as a contractor, it's like, oh, you're going to do a contract agreement, an IP assignment agreement, an NDA agreement, like every single agreement in the world. I think a lot of times the other kinds of natures can cover confidential information and sharing within the bodies of them.
Yeah, that's a good point. And kind of that list of agreement types, the NDA is really just confidentiality. And as soon as you sign, we call it a definitive agreement, the actual contract, what's going to be happening, those confidentiality terms, the new agreement are going to replace the NDA in its entirety. There's a clause in the section 19, usually it says entire agreement, that says any other agreements are now superseded and everything's wrapped into this, which will have those confidentiality terms. So yeah, if it's going to be a step along the way to do something else, cool. Let's not give it too much to worry about, because it should be wrapped into something down the road.
All right, we got a big word from Bridget. I think we lost Bridget, but we will answer this on her behalf so she can watch it in the recording. They're looking to use a third-party technology company that's an LLC as both a fractional CTO and for their development services. That sounds like separate from their startup. What sorts of agreements would you be looking for to cover that work? And would that differ if some of the compensation was done in the form of equity? Let's start with there, and there's a follow-on question.
I mean, quick answer from me would be, there's going to be some kind of service agreement, probably that third-party tech company has a template of, that is their sort of standard agreement. So the biggest thing that I would be looking for in that type of a situation where you're hiring someone to provide development services is the IP, making sure that your company is going to own what you think you own after you pay them to do it. But then obviously there's going to be all the other stuff that Max kind of talked through in terms of what you're paying them, how you're paying them, when you're paying them. And then I think that last part of the question is about if part of what you're paying is done through equity, that's kind of a different can of worms, because how exactly is it going to be set up? Stock options are typically the way that startup companies compensate people for services, but there's a lot of complexity around issuing options to non-individuals, and you really kind of can't do it. We actually wrote an article about that a couple months ago. But there are some other ways you can kind of get some equity in, or sometimes you end up issuing the equity portion to the owners of the service provider company or whatever. Like there's kind of a decision tree you got to go down depending on what you're really trying to accomplish.
And make sure there's equity involved. You're doing all your internal board consents. Make sure you have those options that are out there to pull, update the cap chart, make sure all that's clean as you go through it.
Yeah, something that I've seen in like downloaded from the internet contractor agreements, like with crammed equity in them. Often you want the equity grant to be completely separate from the contractor agreement. The contractor agreement can reference like, hey, there's a corresponding equity grant with that, but the terms will be set out in the grant documentation as well as the board approvals. So the second question she has is about Gus Launch. So being that the relationship here is fractional CFO and a tech company and whatnot, it might be a little bit more custom than just a standard contractor agreement. But if you are working with a standard contractor, Gus Launch has a contractor agreement, sets up a 1099 relationship. It can have an optional equity component to it. And it will put that clause that I just talked about, which is like, hey, there's going to be equity with this, but it's in the equity docs. Trust those, not this contract agreement for the terms of that. And it'll automatically start an equity agreement on Gus, which will allow you to grant stock. We do have common stock that you can grant if it's super early. Sometimes companies grant common rather than options if they don't want to adopt an option plan and get the 409As and all this stuff like that if it's ultra early. But there's some in-platform help too if you're a launch customer, you want to take a look at that.
It looks like the next two are talking about
LLC
startups
times
that are set up as LLCs that may need to go to a corp, and that's a question we get a lot. And so again, it depends a little bit, because if you're set up as an LLC to start, which is fine. If you are trying to raise funding from like a professional VC fund or any other type of like fund, you're almost definitely going to have to be a corporation, not an LLC. The reason for that is the fund itself is a pass-through entity, and usually there are rules in the fund's governing documents that prohibit it from investing in pass-through entities. Because if the fund had 50 portfolio companies and they were all pass-through entities for tax purposes, then the company would have to provide a K1 to the fund would have to provide a K1 to each LP for each portfolio company, and it would just be a complete nightmare from a tax reporting standpoint. So yeah, you probably will have to convert to a Delaware corporation, or maybe not Delaware, but probably Delaware corporation. Like 90% probably of the companies that we work with that are funded from the Bay Area or from New York or wherever usually end up being Delaware corporations. Now, the interesting question is, do you need to do it before or can you wait? And, if you're raising $500,000 on safes from a bunch of individual investors, from a legal perspective, you could wait, but it depends on what those investors want. So you'd have to kind of talk to them. But if you are selling equity, you're probably going to have to do it, no later than in conjunction with the closing. I don't really think it matters that much if you walk into an investor pitch and you say you're currently an LLC. You just need to make sure you understand and they understand that you understand that part of the deal will be converting to a Delaware C Corp.
Yeah, we often advise that if you're starting, if the goal of your company is basically a high growth tech startup, like you're going to raise funds, you're going to grant equity to employees, the end goal for this company looks like an M&A or an IPO, you can often save yourself a lot of hassle by just starting with a Delaware C Corp. But if it's kind of one of those things where I have a services-based business and it might spin out a product, or I'm not entirely sure the shape of this business is going to take, you might be somewhere in the grayer area where it's could I run this as an LLC? And if that whole fundraising thing doesn't work out, I just keep running my LLC. Your mileage may vary.
Yeah, a couple other thoughts on that too is if you're starting a new software, some new software product company, and you're going to self-fund it, and you're going to lose a bunch of money in the first couple of years, you really should talk to your own sort of tax advisor about your situation, because it might be worth the extra work to set it up as an LLC to begin with, but it might not be. It's very much dependent on the situation. And then the other thing is, I don't know if the group is familiar with QSBS or Rule 1202, qualified small business stock.
Launch customer should be, but maybe not everybody here is going to be a launch customer.
Right.
We swing that from the rooftops.
Yeah, but that's something that can be pretty beneficial, but it only works if you're a C Corp. There's a 5-year holding period. So, if you're not really gaining anything from being a pass-through entity in the early years, you might gain something from, being a C Corp in the early years, so you can start that 5-year clock. I think right now, if you qualify, which most tech startups do, when you sell the company, each stockholder gets a $10 million gain exemption from income tax, which is awesome.
Yeah. And that's also very important to angel investors too, because it's per company and they're investing across dozens, if not hundreds of companies over their investing career. So often what you'll find with counsel and later stage, good deal leads, is keeping that QSBS status, not just for your grants, but your entire share class, because you can blow it for the entire common share class or other things. And that is no bueno.
Yep.
Oh, the classic LLC question. All right. Back to the time is of the essence. So anonymous attendee asks, are you suggesting that we should not have time of the essence in the contract, or it's good to have?
Yeah, so I'll be more clear about that one. If you are providing the services or the goods, I would always avoid times of the essence if possible, because you're opening yourself up to additional liability and damages. If you are doing this, if you're having services done for you, you include that, I would expect that pushback. If they have counsel and it's not a position or a relationship where it is required. To your second part of how to get an employee or contractor or service provider not to waste time. One is vetting, right, ahead of time. That's really a concern. Let's do some extra checks to see if that's the right fit just from a business line. And the contract itself, you can still have performance milestones for payments rather than pay all up front. Either pay by time or by delivery of whatever's happening. And you can still institute penalties, interest, wherever you want to, especially late payment or the services are wanting, then there's a refund in there. So you can still achieve those goals of having those motivators out there. But time is of the essence is a huge potential burden for either party that I would only recommend if it has been well thought out, well investigated, and then actually applies to that business relationship, such as a shipping to distributor, where that really does come into play and they're prepared for it and the insurance is aligning. But that's a serious clause to have in there.
I think this goes back to that, like, these contracts aren't self-executing, but the more clauses that are in there that would give, when something goes wrong, somebody the ability to like sue you or like build a case against it. It's like, if you had time is of the essence in there, you give them the ability to say, you didn't do it fast enough that I required, and that was in the contract. Therefore, like, I can breach this, or I can end this, or I can actually get damages or something like that. We all know how work goes.
Right. Instead of like indirect damages, or like they could get rid of the liability cap. So if you say, liability cap for this is the total amounts paid over the past 12 months, that can be excluded from that cap. So it just really can open up either party to it. And I should do a better job. I'm not saying it's a bad clause. This is a really good example of a 5-word sentence or statement that has a huge impact that you'll make sure that you're at least flagging it to investigate.
Yeah. How many people throw ASAP into emails all the time? And it's like, I just hear that. Like, time is of the essence. Yeah, of course it is.
Don't drag your feet.
Yeah, we're all going to die.
But yeah, I guess meant just to be really clear and pretty simple example of those terms of art that can get in trouble if you don't fully understand what's going on.
Awesome. We got 3 more, and then maybe some in the chat. Thank you very much for your extra time. This question is restricted stock options or options to your advisors. What are the pros and cons?
It's probably restricted stock or stock options is what we're probably talking about. I'm not sure if there is something called restricted stock option. Typically, startup companies are going to issue options because it's usually a more palatable tax situation for the person receiving the equity. Advisors are also not normally W-2 employees, so they would only qualify for non-qualified stock options, not incentive stock options. So if you issue options to an advisor, they have an exercise price, they have to pay for them at some point. But there's no tax hit to them when you issue the options to them. They would not pay taxes on the value of the shares until they are vested and then they exercise them. And at that point, I think, the advisor would have a tax liability that's equal to, basically, it's based on the difference between whatever their exercise price was and what the value of the share was when they exercised it. And so usually nobody exercises those until there's an exit, and then they have the money to pay the taxes and everybody's happy. If you issue them restricted stock and they're not paying for it, like if they're buying it, that's one thing. But if you're just trying to give them stock as compensation, then the IRS treats the value of the shares that you issue them as income. And that's usually not acceptable because, it depends, right? If you're in week 2 of the company and you haven't done anything yet, then, it's not going to be a big deal. But if you already, you're 4 years into it, you've got, a bunch of customer contracts, or you have patents or something, valuable in the company, you're not going to be able to say these shares aren't worth anything. And so you're going to issue them stock that has some real value that then they have to turn around and pay taxes on. And usually that doesn't work.
Yeah, since we start companies brand new, their par value is 4 zeros and a 1. I think it's like 1/10 millionth. Early on, like, you issue that to the founding team, we tell you to send the money, even though if you issue 5 million shares to yourself and it's $50, still send the money to the company, because that absolves you of the income tax gain, even for that $50. Super clear transaction. A month goes on, you bring on an advisor, you can probably still issue them common. You're not managing a stock option plan at that low value. But as soon as you raise funds, you get revenue, you get customer lists, you get data, anything that gives your company value, there's going to be some point where issuing common at a 10 millionth of a dollar just doesn't make sense anymore. And even if you have grown a tiny bit, if you're worth 50 cents, a share, asking a new employee to like come on, you're giving an employee be like, oh, and by the way, to buy your stock option, like you need to give us like 5,000 grand. Like most people are just like not used to that when they join employment. So you pretty much have a stock option plan at that point. But I do think there's a couple months a year, depends on how fast you're growing, how much you're throwing at it, who's involved in it. But there's a tipping point where the company is now more valuable than when it started. And that's usually when the option plans get involved. This is a common one too. PBCs, public benefit corporations. Red flag for VCs, just as good as a Delaware C.
I mean, it very much depends on what the focus of the investor is. There are like impact investors that could be super attractive to. But if you're sort of aimed at the typical investor, those really, and this is completely my opinion, but the public benefit corp it is possible that you sort of fit into a niche that is really hard to match. Because if you were a full-blown nonprofit and you had tax exempt status, you could go after donors and they would receive a tax receipt and they'd have some kind of tax benefit to donating to your cause. If you were a full-blown for-profit corporation, then everybody's looking for a return and they're expecting to have, a board that is solely focused on maximizing shareholder value. But if you're this public benefit corp, yeah, there probably are niche investors where that's really, interesting. But there's a lot of people on both sides of that. You're not going to be interesting to people that are looking to make charitable contributions, and you're probably not going to be as interesting to VCs that are solely focused on maximizing their investors' investment. So it can work, but it can also kind of put you in a weird spot.
Cool. Yeah, I've seen very similarly, and I do think the best, if you're a brand new company, like you can become a PBC later if you thread the needle, and you're a company like Tom's or whatnot, which does they give shoes away as they sell shoes. It's strategically relevant to their business model, and it might drive more revenue, which would make investors happy and whatnot. But they landed at that position after being successful in something. So we often say, don't hand wring too much over the early days. Like if you're just proving a market exists, a need is being met, and you have, that goal of, is this a for-profit company or a non-for-profit? Later on, you can kind of layer on some of those things. You don't even have to start as a PBC to be B Corp certified or anything like that. If it's, strategically relevant, or if your investor base is in that niche and it makes sense. Cool. I think we only have too much. Again, super thank you. You guys gave me 45 extra minutes, but this has been a ton of fun. The contract that we reviewed, Ed McFadden is saying it looks like it's more geared towards a development. Would it look very similar for sales, or would that be a whole different set of pitfalls?
Yeah, so somewhat similar. If you think about those three sections, right? Sections 1 through 4, 5 through 10, and 11 through 20. Those last two groups probably be pretty similar. But how you figure out what the service is going to be described as, what your compensation will be, especially for salespeople. As a previous salesperson, you do get a lot more variables, so a lot more things to think through about commission, timing of payments, when you get paid versus when money goes out. So not too different structurally. You still want to keep stuff confidential. You still want to make sure that they're not representing themselves the way they should be for the company. You still want to have governing law somewhere. But those first couple of sections for the extra obligations and compensation services, you need to be thought through that specific lens. And that's for a contracting sales person, right? If you have a true employee who's doing sales, that's a W-2, and that'll just be captured differently, an employee, either offer letter or employee agreement. You get the whole at-will employment stuff, but sales folks get a little more thought in that comp model, so it's a big driver for them to be involved.
All right, two more. This one's a can of worms and should probably be in yet a whole other webinar, but how you determine the valuation or valuation cap, more specifically for a safer convertible note in an early angel round. What are your guys out of the pocket answers for this one?
I mean, It really is not usually based on any metric of actual value. Yeah, exactly. It's really very much usually sort of a negotiated number that your lead investor is comfortable with, and that you're comfortable with. So yeah, that's a great question. I get that get that all the time, but there's not really like it's not going to be based on revenue. It's not going to be based on hardly anything that you can really put a number in. It's just kind of where you are, what you think your potential is, and what you think and what your investors think it is, and you kind of land on a number that everybody can live with.
I think the easiest stuff too is like certain industries have different capital requirements, and it's easier to think about it in terms of percent ownership than it is like, how much is my vaporware company worth right now? And it's like, oh, if you're gonna, sell off 50% of your company in your seed round, like that's a really bad deal. And a good investor would say, that's also a bad deal. I don't want a founder owning less than half the company after their seed round or whatnot. But if you're a medical devices company that has a long path to, getting into market or going around regulations, or if you're just an app company that, can access the entire consumer world, what percentage that cap represents and how much money is going in the seed round can be a bit more of a helpful guiding stick, where it's like, oh, if you sell off 15% of your company because you needed to raise $500,000, so you put a low millions cap, maybe everybody can be happy with that. Once you get later on, though, I know we're in weird times now where it used to be like people raised $2 million on safes, just rolling along and whatnot. Maybe the price round is going to come in a little bit earlier. Maybe the convertible note's going to come with the seed round at bigger terms or whatnot. But then you can hopefully have more negotiating, productive negotiating conversations around a later stage company that might have revenue or figures or monthly active users or something like that. And there should be a lawyer on the side of the investor at that point too. So deeper negotiations. All right. The last question is from Sherry. Is there a list of the type of shares that can be offered?
I actually have a presentation tomorrow, and I actually have a slide with that on there. I'll send it to you, Ryan. You can share it around.
Yeah, I'll send that with the follow-up materials. And can you can I have your permission to share the redlined version of that document with the follow-up materials now that it won't be cheating?
No.
Lawyers told me no, I'm leaving.
So I'll say yes with a caveat, as we do with all of our clients. Like, that is a starting point template, and if you want to use it, engage it at your own risk. So as long as I have the disclaimer from the attorney, that's not a Foursquare provided client legal advice thing. If you want to have it as a learning tool, perfect. If you want to reach out to see how can we tweak that to work with our company, great. But I just want to make sure that while it is a tenant and contractor agreement, and it could be fine as is, just do me a favor and not say, look, I got some Foursquare, it's perfect.
Yeah,
get us in trouble.
I would say do not download documents off the internet and just sign them and say, like, I know what this is doing, because that you're going to be much more on the scale of $70,000 to $100,000 in corporate cleanup if good things happen, then you'll be on the lower end of that scale. Because
as far as being able to see what the original version was, but by all means, it's good to have that distinction between the two and what those simple changes can be aware of.
Awesome. Well, like I said, this was a ton of fun. I'm so glad you guys came in here and were ultra generous with your time. This is a kind of a cool area of conversation that I'd like to have more of. And I think we've identified a number of cool topics that I think that our audience would get value out of. Obviously, we had really strong attendance. I mean, we went so far over that. We thank you for the 23 of you who are sticking with us, but I saw us in the upper 60s or 70s earlier. Jesse, Max, awesome. Thank you for being Gus Launch partners. Thank you for sticking with us. For everybody still here, we'll send out a recording. We'll send out those materials. If you're a launch customer, you can find Foursquare right through the platform. I believe you can help me with this because we are not a referral service. We do not refer people to lawyers. We're a directory service, and we just give people lawyers and they can reach out. But if anybody on this call wants to reach out to you guys directly, they can do that, right? Like we can provide them just emails or whatnot. And that's cool. There we go. You put it up there.
Absolutely.
Full circle. Yeah, absolutely. Looking forward to it.
Have a great week, everybody. Thanks again. And look for more programming from us, Foursquare, and good luck with your startups.